The carpet in Courtroom 7 of the Fulton County Courthouse smelled like old rain and floor wax, the kind of smell that settles into a building over decades and never quite leaves. I had been sitting in that room for 4 hours. I knew because I'd watched the clock above the bailiff's station move from 8:47 to 12:51, and I'd counted the ceiling lights twice. 8 of them. Fluorescent panels set into drop tile. 2 burned slightly dimmer than the rest. I noticed things like that. 31 years as a civil engineer will do that to a man. You start seeing load-bearing details everywhere, even in rooms where the only thing being weighed is your life. Arthur Wynn sat to my left. He had a folder on the table in front of him, thick with tabbed documents, and he hadn't opened it yet. Not once in 4 hours. I'd noticed that too. Across the aisle, Renata Voss was arranging her papers for the 3rd time. She was precise about its stacking, squaring the corners, separating exhibits by colored tabs. She had the particular energy of someone who already knew the outcome and was simply performing competence for the record. Her client sat beside her in a navy blazer I didn't recognize. Sylvia had bought it recently. The cut was different from anything she'd owned when we were together, sharper at the shoulder, more deliberate. She looked like someone who had been preparing for this room for longer than I had realized. Renata leaned over and said something close to Sylvia's ear. Sylvia smiled. It wasn't a large smile, just the corner of her mouth. Controlled. Private. The kind of smile people make when they believe the hard part is already over. I looked back at the ceiling. 8 lights. 2 slightly dim. The bailiff's shoes made a particular sound on the tile near the door, a compressed squeak on every 3rd step, consistent enough that I'd mapped his patrol without looking up. The air conditioning cycled on at irregular intervals, and each time it did, the papers on the clerk's table shifted slightly. I had been cataloging these details for 4 hours, not because I was afraid, but because I had learned a long time ago that the mind goes where you point it, and I preferred to point mine at things I could measure. Arthur had billed me $450 an hour for today. I had not asked him what was in the folder. He had told me 3 days ago that I would understand everything when the time came, and that the sequence mattered. I'd worked with enough structural engineers to know what he meant. You don't pull the keystone until the arch is ready to fall. Sylvia said something to Renata, and they both looked down at a document. I watched the back of my wife's head, the woman I had been married to for 19 years, the woman who had shared a bed with me through 2 moves, 1 miscarriage, and the years when money was tight enough that we ate rice 4 nights a week, and I felt something that wasn't quite anger. It was more like the specific, quiet clarity that comes when you have been waiting a very long time and the wait is almost over. I had been in this building once before, 14 months ago, when Sylvia's attorney filed the initial petition. I remembered the smell then too. The door at the back of the courtroom opened. I didn't turn around immediately. I heard the footsteps lighter than the bailiff's, moving with a kind of careful deliberateness that I recognized the way you recognize a voice you've known since it was small. Then I did turn. My son Owen walked in, and he was carrying something under his arm, and his face was set in an expression I had never seen on him before. Not nervous, not uncertain, but resolved in the particular way of someone who has been keeping a secret for a very long time and has finally decided the time for keeping it is finished. I want to tell you how we got there. I want to start at the beginning, which was not this courtroom, and not the filing, and not even the morning Sylvia told me she wanted a divorce. The beginning was earlier than all of that, in a house I had spent 11 years building into a home, in a life I had spent 19 years believing was real. I want to be precise about where this began, because I've spent a long time thinking about it, and I've concluded that the beginning wasn't a single moment, but a series of choices I made that seemed reasonable at the time and look different now. My name is Calvin Merritt. I'm 54 years old. I spent 26 years as a civil engineer, bridge infrastructure, drainage systems, load calculations for structures that had to hold their weight across decades. I retired early from the firm, took on consulting work, and built a life in Decatur, Georgia, that was quieter than the one I'd planned, but better in most of the ways that matter. The house on Ridgemont Drive has 4 bedrooms, a yard that backs up to a stand of loblolly pines, and a driveway I resurfaced myself in the summer of 2014. I know this because I have the receipts. I keep receipts for everything. That is the engineer in me, and it is the only habit from my professional life that turned out to be useful in ways I never anticipated. I met Sylvia in the spring of 2000 at a conference in Atlanta, not a romantic setting by any measure, a ballroom in a downtown hotel where someone was presenting on municipal water management. She was there for a client. She had an accounting degree from Georgia State and was working for a mid-size firm that handled financial audits for construction companies. She was the smartest person in the room, and she knew it, and she didn't need to announce it. We talked for 40 minutes in the hallway after the presentation. I asked for her number before I'd made any conscious decision to do so. We were married 18 months later. 23 years. That's how long we were married. I want to say that clearly, because I think numbers carry weight that words sometimes don't. 23 years is long enough that you stop seeing a person the way you saw them at the beginning and start seeing them the way you see a room you've lived in. You know where the light falls in the morning. You know which floorboards creak. You stop noticing the things that were once remarkable. That is not a criticism of marriage. That is just what time does. Owen was born in 2006. He came early, by 3 weeks, and spent the first days of his life in the NICU at Emory, and I stood outside the glass and counted his breaths. He came home in a car seat we'd installed and reinstalled 4 times to make sure it was right. He grew up in the house on Ridgemont Drive, went to a private school in Druid Hills that cost more per year than my first salary, and became, over the course of 18 years, a person I did not entirely recognize because he was so much more capable than I had been at his age. I worked overtime through most of Owen's childhood. That's the part I don't say to make myself sound like a martyr. I say it because it's relevant to what happened next. I was on job sites by 6 in the morning and sometimes not home until after dinner. Sylvia managed the house, managed Owen's school logistics, and managed our finances. This last part seemed natural at the time. She had the accounting degree. She had the professional training. She set up the joint accounts, handled the investment portfolio, paid the bills, and provided me with a monthly summary that showed savings growing steadily and no outstanding liabilities. I looked at those summaries the way I looked at the light bill. I confirmed the number was in a reasonable range and moved on. That was my mistake. I want to say that plainly, because I've heard too many stories where the person telling them refuses to acknowledge what they got wrong. I trusted Sylvia with our finances not because I was naive about money, but because I was deliberately incurious. I didn't want to audit my own marriage. The irony of that is not lost on me. For most of our years together, Sylvia was careful. That's the word I keep coming back to. She was careful the way a good accountant is careful, methodical, if precise, and always prepared with documentation when documentation was needed. If I asked about an expense, she had the receipt. If I questioned a transfer, she had the explanation. The explanations were always reasonable. They were always delivered calmly, without defensiveness, and they always made sense. That is, I understand now, the most dangerous kind of lie, the kind that sounds exactly like the truth. The first thing I noticed in 2018 was the phone calls. Not the content of them. I never heard the content, but the pattern. Sylvia had always taken calls at the kitchen table or from the couch, the way people do when they have nothing to hide. Starting sometime in the spring of that year, she began stepping outside. Not every call, maybe 1 in 5, she would look at the screen, stand up, and go to the back porch or the front steps, and she would be out there for 10 or 15 minutes. When she came back in, she would set the phone face down on the counter and continue whatever she'd been doing. When I asked who had called, she said it was work. A client with boundary issues, she explained once. Someone who called at odd hours and needed to be handled carefully. I understood that. I had worked with clients like that. I said nothing more. I want to be honest about something. I am not a jealous man by nature, and I was not jealous then. What I noticed in 2018 was not a suspicion, it was a pattern. Engineers notice patterns. It's not something I decide to do. It's something that happens automatically, the way a musician hears a note that's slightly off pitch. I filed what I observed and moved on. In 2019 and into 2020, other things shifted. Sylvia began buying clothes more frequently, not extravagantly, but noticeably. She had always dressed well, so the change was subtle enough that I might have missed it if I hadn't already been paying closer attention. She went out on Saturday afternoons more often, usually for 2 or 3 hours, usually with explanations that were specific and plausible: a friend's birthday lunch, an errand that took longer than expected, a yoga class she'd decided to try. Her phone stayed face down on whatever surface she set it on. When it buzzed, she picked it up quickly and tilted the screen away. I noticed all of this. I said nothing. The explanations were always good. There was one evening in the winter of 2020 that I have thought about since. I came downstairs around 11 and found Sylvia sitting at the kitchen table in the dark, not reading, not on her phone, just sitting. The only light was from the range hood. She had her hands flat on the table and she was looking out of the window at the backyard. I asked if she was all right. She said, "I'm just tired." I believed her. I went back upstairs. I've thought about that evening many times in the past 2 years, and I still don't know what she was deciding, or whether she had already decided, or whether there was a moment in that kitchen where something could have gone differently. I don't know. I only know she was sitting there, and she looked out the window for a long time, and then she came to bed. Then came March of 2021. Owen was 14. I was in the kitchen on a Thursday evening, and Sylvia had left her calendar open on the counter, a paper calendar, which she kept for appointments she wanted to remember without relying on her phone. I wasn't looking through it. I was reaching past it for the coffee maker, and my eye caught the page. The name Dex appeared 3 times that week. Tuesday, Thursday, Saturday. Each entry was brief, just the name and a time. No location, no context. I asked her that evening, as casually as I could manage, who Dex was. She said he was a colleague from a financial consulting group she'd been working with on a new client account. She said it without hesitating, without looking up from the counter, and then she turned the conversation to Owen's upcoming school project. I let it go. I let it go because the answer was smooth and immediate and came with a redirect. And I had spent 20 years learning to trust the way Sylvia handled information. But I remembered the name. I wrote it down in the small notebook I keep in my shirt pocket, the one I use for measurements and site notes and things I don't want to forget. I wrote it down the way I would write down a load figure that didn't quite add up, something to check later when I had better data. I did not know yet what I was checking for. I only knew that the name Dex appeared in my wife's calendar 3 times in 1 week, and she had told me he was a colleague, and her voice when she said it had been exactly as steady as it always was. And that steadiness, which I had trusted for 23 years, was the thing I was no longer sure about. That was March of 2021. I know the date because I checked the notebook later. I had written it at the top of the page the same night, the way I dated every site observation, 26 months before the hearing. I closed the notebook. I put it back in my pocket. I went to bed that night at the same time I always did. The house was quiet. The pines behind the yard were still. I lay there for a while, listening to the particular silence of a home that holds more than you know, and then I went to sleep. The morning Owen told me about the man. We were sitting in the kitchen before school. He was 16 then, still in that particular phase of adolescence where he talked to his cereal more than to people. And when he looked up and said, "Dad, I need to tell you something," I put my coffee down, not because I expected what came next, because of the way he said it carefully, the way you carry something you're afraid to drop. He said he'd been home alone 2 Tuesdays ago while I was in Chattanooga for a bridge inspection. He said a car had pulled into our driveway around 4 in the afternoon. He said his mother had gone outside to meet it. He said the man who got out was someone he'd never seen before. Tall, he said, maybe 45, dark jacket. He had a way of standing, Owen said, like he was used to waiting for someone to come to him. I asked Owen what the car looked like. He said it was a silver Mercedes, an older model, and that the man had stayed inside for about 2 hours before leaving. He said his mother had told him afterward that it was a contractor coming to look at the water heater. The water heater had not been replaced. I knew this because I had been the one who called the plumber the previous spring, and the plumber had told me it still had 3 to 5 years on it. I did not say any of this to Owen. I asked him if he was okay. He said yes. I asked if this had happened before. He paused and said he wasn't sure once, maybe about a month before that. I thanked him for telling me. He nodded and picked up his backpack and went to school, and I sat at the kitchen table with my coffee going cold and thought about a man named Dex Calloway, who I had met exactly once at a firm event 18 months ago, who had shaken my hand and told me he was in commercial real estate, and whose name had appeared in my wife's calendar 3 times in 1 week. I called Arthur Wynne that afternoon from my car, parked in the lot behind the hardware store on Ponce de Leon. Arthur had been my attorney since 2011 when I'd needed him for a contract dispute with a subcontractor in Gwinnett County. He was methodical and unhurried, and he did not ask unnecessary questions. I told him I needed to know my options. I told him I wasn't ready to do anything yet. He said that was fine, and that I should start keeping a written record of dates, times, and observations, nothing interpretive, just facts. I said I already had. He said, "Good. Call me when you're ready to move." That call was in September of 2021. By the time Owen came to find me in the garage 14 months later, I had been keeping the notebook for 20 months. 20 months of dates, times, and license plate numbers, nothing interpretive, just facts. I did not tell Sylvia what Owen had said. I went home that evening and made dinner grilled chicken, rice, green beans, and we ate together, and she told me about a problem with a client at her firm, and I listened and asked the right questions, and afterward she went upstairs to read, and I washed the dishes. I was careful about all of it. I had spent 23 years learning the rhythms of that house, and I used them now the way I used to use survey data to establish a baseline before measuring deviation. The deviation showed up the following week at the bank. I'd gone to our branch on Claremont Road to update the address on a small investment account, a routine thing, the kind of errand I'd been putting off for months. While I was there, I asked the account manager if I could review the contact information on our joint checking. The account manager, a man named Marcus Teal, who had the careful manner of someone trained to deliver bad news neutrally, pulled up the account and then looked at me with an expression that was not quite confusion and not quite concern. He said the primary contact number on the account had been updated 14 months ago. He read the number back to me. It was not my number. It was Sylvia's. I asked him to confirm that all account notifications, transfers, withdrawals, balance alerts had been going to that number. He said yes. I asked him when the last time was that I had received a notification directly. He checked. He said the record showed the contact update had been processed in August of 2021, and that prior to that, notifications had gone to a number he read back, which was my cell phone. I recognized my own number. I had not recognized the other one immediately because it was Sylvia's work cell, a number I rarely called. Marcus Teal asked me, in the careful way of someone who had processed enough family disputes to know when to be careful, whether I'd like to request printed statements for the account history. I said yes. I said I'd like 5 years. He asked whether there was anything specific I was looking for. I told him I was just doing a financial review. He nodded and said the statements would be ready in 3 business days and that I could pick them up at the branch or have them mailed. I said I'd pick them up. I did not want them arriving at the house. He printed a confirmation slip and handed it across the desk. His handwriting, where he'd noted the request date, was very neat. He held it out, and then before I took it, he said, quietly, "Mr. Merritt, if you find anything in those statements that concerns you, we do have a fraud review process. It's confidential. I can leave you the contact information." He said it the way a person says something they have been trained not to say directly, but have decided to say anyway. I looked at him. He looked back at me without expression, the careful neutrality of a man who had processed enough of these requests to know what they usually meant. I took the slip. I thanked him. I told him I'd keep that in mind. He nodded once, and I understood that he had already understood and that he had said what he could say within the limits of what his job allowed him to say. I sat in the parking lot for 11 minutes. Then I drove home. The call from Carol Fitch came on a Thursday afternoon in late October, about 3 weeks after the visit to the bank. I was on the back porch checking drainage calculations on a project in Marietta when my phone lit up with her name. Carol had lived next door for 20 years. She was a retired high school history teacher, widowed, and she had the particular attentiveness of someone who had spent decades noticing when students were not paying attention. She called me maybe 4 times a year, never without a reason. She said she was sorry to bother me, but there was a man outside. She said he had been standing on the sidewalk in front of my house for about 20 minutes, taking photographs, not of the street, she said, of my house specifically, and of my truck in the driveway. She said she had watched him from her front window, and that when she'd opened her door to check the mail, he had not stopped or acknowledged her. She said he had a good camera, not a phone, a camera with a lens on it. I asked her to describe the car he'd arrived in. She said it was a dark blue Audi, parked just past my driveway. She said it had an Atlanta parking sticker on the rear windshield. I knew the car. I had seen it once before, in September, parked outside the restaurant where Sylvia had told me she was having lunch with a colleague. I had driven past without stopping. I had written the make and color in my notebook that evening, along with the date, because I had learned to write things down before I understood why they mattered. I knew who the car belonged to. Her name was Renata Voss. She was a family law attorney with an office in Buckhead, and I knew her name because Arthur Wynn had mentioned it to me 2 months earlier, not in connection with my case, but in passing, as someone who was known for aggressive asset protection filings. I had written that name down too. I thanked Carol and told her she'd done the right thing calling me. She said she hoped everything was all right. I told her it would be. I did not know yet if that was true, but it was the answer that would end the call without requiring explanation, and I needed to get off the phone. I called Arthur Wynn before I had walked back inside. He picked up on the second ring. I told him what Carol had described the man, the camera, the dark blue Audi. I told him whose car I believed it was. There was a pause on Arthur's end, the kind that meant he was writing something down. Then he said, "She's building a file, probably property documentation, maybe grounds for emergency asset freezing." He said Renata Voss had used that approach before photograph the marital home, establish its current condition and market context, file for a temporary restraining order on asset disposal before the other party knows litigation has started. He said it was aggressive, but not unusual. I said I knew. He asked me what I wanted to do. I told him I needed more time. He said, "Calvin, she's not going to give you more time." I said I understood that. I said I needed 2 weeks, maybe 3. He said he'd start preparing our response filing, but that I should call him the moment anything changed. I said I would. That evening, Owen came to me in the garage where I was checking the oil in my truck, a thing I do when I need to be doing something with my hands. He stood in the doorway for a moment before he spoke. He said he'd found something. He had been looking for his birth certificate in the filing cabinet in the upstairs hallway, the one Sylvia kept locked, but which Owen had known the combination to since he was 14, because I had given it to him in case of emergency. He said he had found his birth certificate. He had also found, behind a manila folder at the back of the bottom drawer, a set of bank statements he didn't recognize. He said the account name had my name on it, Calvin J. Merritt, but the account number was one he'd never seen before. He said the statements went back about 3 years, and that the balance on the most recent one was listed at more than $340,000. He had photographed every page with his phone. He held the phone out to me. I took it. I went through the photographs one by one, standing under the garage fluorescents with the smell of motor oil around me. The account was real. I could see the routing number, the branch code, the transaction history, deposits, mostly in amounts between $8,000 and $20,000, spaced irregularly over 34 months. Withdrawals to a name I did not recognize at first, and then did Dex Calloway, listed as payee on 11 separate transfers totaling just over $91,000. I handed the phone back to Owen. He was watching me the way he had watched me in the kitchen 2 months before, carefully, waiting to see what I would do with what he'd given me. I asked him if he had said anything to his mother about what he'd found. He said no. I told him he'd done well. I told him not to say anything to anyone. He nodded. He went back inside, and I stood in the garage for a while longer with the fluorescents humming above me and the statements I had never seen laid out in my memory like a survey map of ground that had been shifting under my feet for years. I called Arthur Wynne the next morning and told him we were ready to move. The papers arrived on a Saturday in April. Owen turned 18 that afternoon. We had a small gathering, his grandmother on my side, 2 of his friends from school, Carol from next door. Sylvia had baked a cake from a recipe she'd found online, and she was pleasant all afternoon, refilling glasses and laughing at the right moments. Owen opened a few gifts at the kitchen table. I stood near the back door and watched him, and I thought about the fact that he had been 15 years old when he started. I thought about that every few minutes throughout the afternoon, and I didn't let it show, and I don't think anyone noticed. The guests left by 7. Owen went upstairs. I was washing dishes when Sylvia set the folder on the counter beside the sink. She didn't say anything. She just set it there and stepped back, and when I turned to look at her, she was smiling, not a wide smile, not triumphant exactly, but the particular smile of a person who has been holding something for a long time and has finally put it down. The folder was thick, 3/4 inch, maybe more, with a rubber band around it and a law firm's name embossed on the cover page, Voss and Hargrove, Family Law, Atlanta. I dried my hands. I picked it up. I didn't open it yet. Sylvia said she thought it was better to do this now, while things were still manageable. She said she hoped we could be adults about it. She said she had already thought through the arrangements carefully, and she believed the proposal inside was fair given the circumstances. I asked what circumstances she meant. She said she thought I knew. I said I'd read it tonight and we could talk in the morning. She nodded and went upstairs. I heard the bedroom door close. I heard the television come on. I sat down at the kitchen table and opened the folder. The petition ran 42 pages. I read it straight through, then started again from the beginning. Sylvia's attorneys had organized it carefully. The language was precise, the framing deliberate. The core allegations were financial control and emotional abuse. According to the petition, I had systematically restricted Sylvia's access to household funds, monitored her spending, and used financial pressure as a means of control throughout the marriage. There were dates. There were characterizations of specific conversations I remembered differently, or didn't recognize at all. There was a section describing a pattern of emotional withholding that had, according to the document, caused Sylvia ongoing psychological harm. The allegations were structured to accomplish something specific. Under Georgia law, a credible claim of financial abuse during marriage can prompt a court to impose temporary restraining orders on asset access while proceedings are pending. If the petition was accepted as filed, I could be restricted from our joint accounts, our investment portfolios, and potentially the house on Alderton Drive before a single piece of evidence had been examined. Sylvia's attorneys knew this. The 42 pages had been written by people who understood exactly what they were doing. I closed the folder at 11:15. I set it on the counter where she had set it. I made a pot of coffee, and I stood at the window and drank 2 cups while the neighborhood went dark. The coffee was lukewarm by the time I poured the second cup. I drank it anyway. I did not call Arthur Wynne that night. He had told me 3 weeks before that when the petition arrived, I should call him regardless of the hour. I didn't call. He had been waiting for this call for months. I knew that. And he knew I knew, but I needed to sit with it first. I needed to understand the full shape of what she had built. The 42 pages were not improvised. They had taken time. They had taken planning and money and a particular kind of patience that I recognized because it was the same patience I had been practicing for the past 14 months. I went to bed at 1 in the morning. I don't know if I slept. The call from Dex Calloway came on a Sunday morning, 8 days after Sylvia had set the folder on the counter. I was in the front yard checking the drainage channel along the property line, a low spot near the sidewalk that collected water after heavy rain and had needed regrading for 2 seasons. Carol Fitch was deadheading her roses on the other side of the fence, the way she did most Sunday mornings when the weather allowed. We had exchanged a few words about the forecast. It was an ordinary morning. My phone rang. The number was one I didn't recognize, but I had written it down 4 months earlier in the notebook, under a date in August, next to the words DC/work cell. Confirmed. I answered. The voice was smooth, unhurried. He introduced himself by first name only, as though we had met before under better circumstances. He said he understood I had received the filing. He said he hoped I was taking it seriously. He said, and I want to be precise about this, because I wrote it down afterward, word for word, Calvin, you should understand that Sylvia's attorneys have been building this case for over a year. The financial documentation alone is going to be very difficult for you to contest. My advice, and I'm offering this genuinely, is that you accept the proposed terms before this gets more expensive for everyone. He said my advice the way a man says it, when he has already decided the other person has no options worth considering. I did not respond immediately. I looked at the drainage channel. I looked at the low spot near the sidewalk that had been collecting water for 2 seasons and that I had been meaning to fix. I had learned that silence makes people say things they wouldn't otherwise say. He said, "You're not in a strong position here. I think you know that." I said, "I appreciate the call." There was a pause. He said, "I hope you'll think about it." I said I would. I ended the call. Carol was still at her roses. She had stopped deadheading. She was looking at me over the fence with the particular expression of a woman who has spent 30 years in a high school classroom and knows when something has happened that she is not supposed to have heard. I told her it was nothing to worry about. She said, "Calvin, that didn't look like nothing." I told her I'd explain when I could. She nodded and went back to her roses, and I stood at the drainage channel for another minute, looking at the low spot, and I thought about a man who had called me on a Sunday morning to tell me I had no options, and I thought about the notebook in my shirt pocket, and I thought about Arthur Wynne, who had told me 11 months ago to call him when I was ready to move. I was ready to move. I went inside and called him. Raymond Chu called me on a Tuesday, 3 weeks after Arthur had retained him. I was sitting in my truck in the parking lot of the county assessor's office, where I had just filed an amendment to a property survey I'd been working on for a client in Decatur. It was an ordinary morning. The call came at 10:47. She said he wanted to be clear about something before he gave me the numbers. He said he had checked everything 3 times before making this call. He said that in 14 years of forensic financial work, he had learned not to present figures until he was certain. And he was certain. I told him to go ahead. He said the total amount transferred out of our joint accounts and marital investment holdings over 14 years was $512,000. I sat with that for a moment. The parking lot was quiet. A woman walked past pushing a stroller. I watched her go. Chu continued. He said the transfers had been structured carefully, amounts small enough to avoid automatic flags, spread across different account types and different intervals. He said whoever had done this had either received professional guidance or had done considerable research on their own. He said he had traced the destination accounts as far as the documentation allowed. $280,000 of the total had moved through a series of transfers into an account registered to an individual named Dex Calloway. I said nothing for 4 seconds. Then I asked Chu to send the full report to Wynn's office by end of business. He said it would be there by 3. I sat in the truck for another few minutes after I hung up. The woman with the stroller had reached the far end of the parking lot and turned the corner. The assessor's office door opened, and a man in a gray jacket came out carrying a cardboard tube. The morning went on around me the way mornings do, indifferent to what had just been confirmed. $512,000, 14 years. $280,000 to a man whose name I had found on a receipt in a jacket pocket 20 months ago and filed away without comment. I started the truck and drove back toward the office. I had 2 site visits that afternoon. I went to both of them. Owen came to find me that evening. I was in the study, reviewing Wynn's preliminary response to the divorce petition, when I heard his knock 2 taps. Then a pause, the same knock he'd used since he was small. I told him to come in. He closed the door behind him, which he rarely did, and he sat in the chair across from my desk rather than on the couch by the window. He was sitting the way he sat when he had something to say and wanted to say it correctly. He told me he had been recording his mother's conversations since he was 15 years old. I put down the document I was holding. He said he needed me to understand that he hadn't done it carelessly. He said that when he was 15, he had found a folder of bank statements in the back of the filing cabinet in the garage. The cabinet Sylvia had told him held old tax documents and nothing else. The statements were for accounts he hadn't known existed. He hadn't understood all of what he was looking at, but he understood enough to know it wasn't something that should be hidden. He said he'd spent 2 weeks researching before he did anything else. He'd looked up Georgia recording law specifically. Georgia was a one-party consent state. He explained only one person in a conversation needed to consent to the recording, and that person could be the one making it. He had confirmed this from 3 separate sources before he started. He had 47 recordings. He said some of them were short fragments of phone calls he had overheard from the hallway, conversations at the kitchen table that he had captured by leaving his phone face down near the fruit bowl. Others were longer. He said there was one from the previous November, 43 minutes, in which his mother had a phone conversation in the study while Owen had been in the room she thought was empty. He said she had spoken about the divorce petition, specifically the timing, the allegations, the expected outcome. She had referred to the financial control claims as a strategy. She had used that word. He said he had given everything to Wynn 2 days ago. I asked him when Wynn had confirmed the recordings were admissible. He said yesterday afternoon. I looked at my son for a moment. He was 18 years old. He had been carrying this for 3 years through his sophomore and junior years of high school, through college applications and early admission, and every ordinary thing that had happened in this house since he was 15, and he had carried it without telling me. He had carried it carefully, with research and patience, and a precision that I recognized the way you recognize your own handwriting. I didn't ask him why he hadn't told me sooner. He had already answered that not to me. But I had heard the answer in the way he'd explained himself, in the sequencing of what he'd said. He had needed to be old enough to testify. He had needed enough material that no single recording could be dismissed as anomalous or taken out of context. He had needed, in other words, exactly what he had: 47 files, 3 years of documentation, and the legal standing to present it himself. I said, "You did this right." He said he had tried to. We sat in the study for a while without talking. The house was quiet. Sylvia was out. She had been out most evenings for the past several weeks, which I had noted and not commented on. The lamp on my desk made a small, warm circle, and everything outside it was dim. I called Wynn at 8:15. He confirmed what Owen had told me. The recordings had been reviewed by a colleague with specific experience in Georgia evidentiary standards. All 47 files were admissible. The financial report from Raymond Chu had arrived at 3 as promised. Wynn had spent the afternoon cross-referencing Chu's findings with 3 of the recordings, and the overlap was, in his word, significant. He said he intended to file the complete evidentiary package with the court 48 hours before the final hearing, in accordance with the scheduling order Judge Hale had issued. Renata Voss and Hargrove would receive the full disclosure at the same time, as required. I asked if he thought Voss would request a continuance. Wynn said she might try. He said he didn't think she'd succeed, given the timeline. I told him to proceed. After I hung up, Owen was still in the study. He had moved to the couch by the window and was looking at nothing in particular: the middle distance, the dark glass, some point between the lamp and the wall. I thought about the garage, 14 months ago, and the account statements I had found on his phone, and the way he had watched me then, waiting to see what I would do. I understood now what he had been doing while he was watching. I told him to get some sleep. He said he would. He stood, and for a moment he looked younger than 18, not like a child exactly, but like someone who had been holding a weight for a long time and had only just set it down. He crossed the room toward the door. At the threshold, he stopped and turned back. He said I needed enough, Dad. I needed it to be enough that no one could say otherwise. I told him it was enough. He nodded once. He went upstairs. I heard his door close, and then the house was quiet again, and I sat at my desk with Raymond Chu's numbers in my head, $512,000, 14 years, $280,000 to a man named Dex Calloway, and I thought about patience, and about the particular kind of courage it takes to stay quiet when you know something, and to wait until the knowing is enough to matter. The hearing was in 11 days. I turned off the desk lamp. I went to bed. I did not lie awake. The courtroom on the third floor of the DeKalb County Courthouse smelled like floor wax and old paper. I had been in that room once before, 22 years ago, for a contract dispute involving a subcontractor who had falsified load-bearing calculations on a bridge approach in Decatur. I had won that case. The room had been repainted. Since then, the walls were a lighter shade of beige, but the 8 recessed lights in the ceiling were the same fixtures, or close enough. I counted them when Renata Voss began her opening presentation. 8 lights. I counted them twice. Renata Voss was good at her job. I want to be accurate about that. She stood at the front of the room with a posture that suggested she had never once been uncertain about anything, and she laid out her case against me in clean Durkheimian sequential order: the joint accounts, the withdrawal patterns, the alleged pattern of financial control that she characterized as economic abuse. She had documents tabbed and numbered. She had a timeline printed on cardstock and mounted on a foam board that a paralegal had carried in and set on an easel near the jury box. There was no jury. This was a bench hearing, but the easel was there anyway, and the timeline was professional and legible from 20 feet. She had prepared. I could see that. She spoke for 19 minutes without notes. Sylvia sat at the table to my left. She was wearing a gray blazer. I did not recognize she had bought it recently, or borrowed it, or it had been in the back of a closet I hadn't opened. She sat with her back straight and her hands flat on the table in front of her, and she did not look at me once during those 19 minutes. Not once. I noticed that. I noticed it the way I noticed structural anomalies, not because it surprised me, but because it confirmed something I had already calculated. Judge Patricia Hale sat at the bench and listened to Renata Voss without expression. She was a compact woman in her early 60s with reading glasses pushed up on her forehead and a legal pad in front of her on which she wrote occasionally and without apparent urgency. She did not interrupt. She did not signal approval or skepticism. She simply listened, and I found that I respected her for it. When Renata Voss finished, Arthur Wynn stood up. Arthur is 63 years old and has been practicing family law in Atlanta for 31 years. He does not raise his voice. He does not use foam board easels. He stood up, buttoned his jacket, and said, "Your Honor, at this time I'd like to call Owen Merritt as a witness." Renata Voss was on her feet before Arthur had finished the sentence. Objection. This witness was not on the original list. Arthur did not look at her. He kept his eyes on Judge Hale. Mr. Merritt was added to the witness list when the supplemental evidence package was filed 48 hours ago. Counsel received electronic notification at 7:14 a.m. On Thursday, the filing timestamp is in the record. Judge Hale looked at Renata Voss. She looked at her for a long moment. Renata Voss said nothing. She had received the notification. We both knew she had received it. Arthur had confirmation of delivery. Judge Hale said, "Overruled. Proceed." Owen walked in from the side door. He was wearing a blue Oxford shirt, the one he'd bought for his high school graduation last spring, the one that still fit him correctly across the shoulders. He was 18 years old, and he walked to the witness stand without looking at his mother and without looking at me. And he sat down, and he placed his hands on the railing in front of him, and he waited. The courtroom clerk administered the oath. Owen said, "I do," in a clear voice. Arthur approached the stand. He asked Owen to state his name and his relationship to the parties. Owen did. Arthur asked him how old he was. 18. Arthur asked him when he had first begun collecting audio recordings relevant to this proceeding. Owen said, 3 years ago, I was 15. The room was quiet enough that I could hear the climate control system cycling in the ceiling. Arthur asked Owen to describe what had led him to begin recording. Owen said that he had heard conversations in the house between his mother and other parties that concerned him, that he had looked up Georgia recording law before he did anything else, that Georgia is a one-party consent state, meaning a participant in a conversation may legally record that conversation without informing the other parties, that he had confirmed this through the Georgia Code, Section 161162, and through a secondary source he described as a legal information database he had accessed through the public library. He said he had wanted to be certain before he started. Arthur asked him how many recordings he had collected over the 3-year period. Owen said 47. Renata Voss wrote something on her legal pad. Sylvia's hands, which had been flat on the table, moved. Her left hand came up and touched the edge of her blazer lapel, just briefly, and then went back down. Arthur asked Owen to direct the court's attention to file number 23 in the supplemental evidence package. The court's audio system had been tested that morning. Arthur had arranged that with the clerk 2 days prior. The court officer loaded the file. Arthur asked Owen to describe what the recording contained before it was played. Owen said, "It's a phone call, November 14th, 2022. My mother is in the kitchen. I was in the adjacent room. The call lasted 11 minutes and 40 seconds. She's speaking with Dex Calloway." Arthur said, "And what is discussed in that call?" Owen said, "She discusses filing a domestic abuse complaint against my father. She talks about the timing, about making sure it was filed before the divorce petition so that it would affect the custody and asset determinations. She uses the phrase, 'lock it in.' She says that if the complaint is on record first, the judge will have to take it into account." Arthur looked at Judge Hale. "Your Honor, the state requests permission to play Exhibit 23A. Judge Hale said, "Proceed." Renata Voss stood. "Objection. Hearsay." Judge Hale looked at her over the rims of her reading glasses, which she had pulled down from her forehead at some point in the last several minutes. She looked at Renata Voss for 3 full seconds. Then she said, "This is your client's own voice. Counsel, that's an admission, not hearsay. Sit down." Renata Voss sat down. The file played. "I am not going to describe what Sylvia's voice sounded like in that room. I am not going to describe the specific words beyond what Owen had already summarized, because Owen had summarized them accurately, and anything I added would be for a purpose I don't have any use for. What I will say is that the recording was 11 minutes and 40 seconds long, and that the room was completely silent for all of it. At approximately the 4-minute mark, I know because I was watching the timestamp on the court officer's monitor, Renata Voss stood up. She stood the way a person stands when they have thought of an objection and are certain it will land. She opened her mouth, then she closed it. She stood there for 2 full seconds with her mouth closed and her legal pad in her hand and nothing coming out, and then she sat back down. Her paralegal, a young woman in a dark blazer who had been taking notes throughout the morning, reached over and touched Renata Voss's forearm, just briefly, the way you touch someone who has gone somewhere else in their head and needs to be brought back. Renata Voss looked at her own hand on the table as though she was confirming it was still there. She did not stand again for the remainder of the recording. When it ended, Judge Hale removed her glasses entirely and set them on the bench in front of her, and she looked at Sylvia, and she looked at her for a long time. Sylvia looked down at the table. Arthur asked Owen about File 31. Owen said that File 31 was a recorded conversation from March 8, 2023, also in the family home, also involving Sylvia and Dex Calloway. He said the conversation concerned the transfer of funds specifically, the mechanics of moving money from the joint savings account into an account that Calloway held at a different institution. He said his mother referred to the amounts in approximate figures. He said Calloway asked whether the transfers would be traceable, and his mother said she had changed the contact number on the bank account to her personal cell phone so that any verification alerts would come to her and not to the joint email address. Arthur said, Your Honor, Exhibit 31A. Judge Hale said, Play it. This file was shorter, 7 minutes, 14 seconds. When it ended, Renata Voss leaned close to Sylvia and spoke in a low voice. I could not hear what she said. I watched Sylvia's face while Renata spoke. I had spent 23 years learning to read Sylvia's face, and what I saw there was not remorse, and it was not calculation. It was something closer to the specific look of a person who has just understood, for the first time, that a door they believed was open has been closed and locked from the outside. Sylvia stood up. She stood up abruptly, the way a person stands when their body moves before their mind has finished deciding, and she reached for the leather bag that was on the floor beside her chair, and she took one step toward the aisle. The court officer near the door, a man in his 40s whose name I later learned was Sergeant Dennis Pruitt, stepped forward and placed himself between Sylvia and the exit. He did not touch her. He simply stood there. Judge Hale picked up her gavel. She did not strike it hard. She struck it once, with precision, the way a person who has used a gavel for 19 years strikes it when they mean exactly what they are about to say. She said, Ma'am, sit down. Sylvia sat down. The room was silent again. Renata Voss looked at her legal pad. She did not write anything on it. She looked at it the way a person looks at an object when they need somewhere to put their eyes. Then she looked across the room, and for the first time that day, she looked at me. I did not look back at her. I was looking at Judge Hale. Judge Hale put her glasses back on. She made a note on her legal pad, a longer note than the one she had been making during Renata Voss's opening. She wrote for perhaps 45 seconds. Then she set down her pen and addressed the room. She said that in light of the audio evidence submitted as Exhibits 23A and 31A, and in light of the forensic financial analysis submitted by Raymond Chu as part of the supplemental package, she was suspending the current proceedings and referring the matter to the Fulton County District Attorney's Office for review of potential criminal charges, including wire fraud, financial elder abuse, and conspiracy to file a false police report. She said that the domestic abuse complaint filed against Calvin Merritt in October of the prior year would be flagged for prosecutorial review. She said that she was issuing a temporary freeze on all jointly held accounts pending the outcome of that review. She said these things in the same even tone she had used for the entire proceeding. Then she said, Mr. Wynn, I want a complete copy of the supplemental evidence package filed with this court by end of business today. Your office will coordinate with the clerk. Arthur said, Already prepared, Your Honor. Judge Hale nodded once. She gathered her papers. She stood, and the bailiff called the room to order, and she walked through the door behind the bench, and the door closed behind her with a sound that was very quiet and very final. Owen stepped down from the witness stand. He walked past his mother's table without looking at it. He came and stood beside me, and I put my hand briefly on his shoulder, just for a moment, just the weight of it, and then I let go. Renata Voss was still sitting at her table. She had both hands flat on the surface in front of her, the same posture Sylvia had held at the beginning of the morning, and she was staring at a point somewhere between the tabletop and the middle distance. Her paralegal leaned in and said something. Renata Voss did not respond. Sylvia did not look at Owen. She did not look at me. Sergeant Pruitt had returned to his position near the door, but he was watching her, and she knew he was watching her. And she sat very still with her bag on her lap and her hands folded over the clasp. Arthur came over and said, quietly, that we should let the room clear before we moved toward the exit. I told him that was fine. I had nowhere I needed to be immediately. I looked up at the 8 recessed lights in the ceiling. They were still on, all 8 of them, burning with the same indifferent steadiness they had maintained through the entire morning. I had counted them at the beginning because I needed something to count. I did not need to count them now. Judge Hale did not recess. She kept the courtroom for another 2 hours. working through the remaining motions with the same deliberate pace she had maintained all morning. The financial disclosure documents, all of them, including the amended ones Raymond Chu had prepared, were entered into the permanent record. The audio files were logged as Exhibits 14 through 22. Arthur had organized them by date, and the clerk processed each one without comment. The judgment came just before noon. Calvin Merritt retains full title to the property at Decatur. All jointly held assets revert to his sole ownership. The court orders an immediate referral to the Fulton County District Attorney's Office for criminal investigation into financial fraud and perjury. The language Judge Hale used was precise and unhurried. The evidence before this court establishes a pattern of deliberate misappropriation over a period of not less than 31 months. She did not editorialize. She did not need to. Renata Voss was asked, in writing, to provide a full accounting of her role in submitting the domestic abuse allegations, specifically what she knew about the evidentiary basis for those allegations at the time of filing, and when she knew it. The letter from the court would go to the State Bar of Georgia as well. I heard Voss say something to her associate as they gathered their materials. I did not hear what it was, and I did not try to. 6 months pass the way months do after something large has ended, not quickly, not slowly, but with a kind of deliberate ordinariness that felt, after everything, like a relief. Sylvia entered a guilty plea in October. Financial fraud. Perjury before the court. The agreement called for a suspended sentence of 3 years and full restitution of $512,000 to be repaid on a structured schedule approved by the court. Her attorney, not Voss, who was no longer practicing, negotiated the terms. I was not present for the plea. I did not need to be. Dex Calloway settled the civil suit in November. He returned $210,000 of the $280,000 he had received. His attorney argued that a portion had been spent in good faith on shared expenses. Arthur did not find that argument persuasive, but the settlement was reasonable, and I accepted it. I have not seen Dex Calloway since the morning of the hearing, when he sat in the gallery and left before the judgment was read. I do not expect to see him again. Renata Voss's license was suspended by the State Bar of Georgia in December, pending the outcome of their investigation. The suspension notice was a matter of public record. I read it once. I did not read it again. Owen was accepted to the University of Georgia School of Law in the spring. He called me from the parking lot of his apartment building, and I could hear traffic in the background. He said, "I got in, Dad." I said I knew he would. He said that wasn't something you could actually know. I told him he was right. I drove him to Athens in late August, 70 miles on I-20 East and then north on 316, and we talked about the apartment he'd already toured, and the orientation schedule and the parking situation near the law school. Practical things. We were good at practical things. The two of us. The drive took just under 90 minutes. For the last 20 miles, neither of us said much. I did not mind the quiet. I had learned, over the past 3 years, that Owen's silences were not empty. They never had been. I helped him carry boxes to the 3rd floor. His roommate wasn't there yet, and the room smelled like fresh paint and industrial carpet cleaner. We set up the desk and the lamp and argued briefly about whether the bookshelf should go on the east wall or under the window. He won. He was usually right about spatial things. I shook his hand in the hallway outside his room, and then I thought that was insufficient, and I pulled him in and held on for a moment longer than I had intended. He let me. He didn't say anything. Neither did I. On the way back, I stopped at the Chevron on Highway 78 just outside of Snellville. Owen and I had stopped there a dozen times over the years after Little League games, after school trips, once after a long drive back from the coast when he was 7 and had fallen asleep in the back seat and woken up asking for something cold to drink. I went inside and bought 2 Cokes from the refrigerated case near the back. The woman at the register didn't look up from her screen. I paid cash. I sat in the car in the parking lot. The afternoon light was flat and even, the kind that doesn't cast much shadow. I opened 1 Coke and drank it. The second one sat in the cup holder on the passenger side. I drove the rest of the way home with it there. I did not open it. I don't know exactly why. I pulled into the driveway on Wisteria Lane in Decatur and sat for a minute before going inside. The kitchen was the same. The table was the same, the one I had been sitting at the night after Owen's birthday, when I read the divorce filing for the first time and counted the clauses the way I used to count load calculations on a bridge spec, looking for the thing that didn't add up. A lot had not added up. I sat down in the same chair. The house was quiet in the particular way that houses are quiet when they have been quiet for a while and are no longer surprised by it. I did not think about Sylvia. I thought about Owen sitting in the witness chair with his hands flat on his thighs and no notes in front of him, answering every question in the same measured voice he had used since he was a boy. I thought about the fact that he had been doing this for 3 years, recording, organizing, waiting, and had said nothing to me. Not because he didn't trust me, but because he understood, at 18, that some things have to be built in silence or they don't hold. I called Arthur Wynne the next morning. He had the final transfer documents ready, and I drove to his office on Peachtree Road and signed them at the conference table where we had met 11 times over the course of the past year. His paralegal witnessed the signatures. Arthur asked if I was all right. I told him I was. He said, "That boy of yours did something most grown adults wouldn't have the patience or the nerve to do." I told him I agreed with that. He slid the last document across the table. I signed it, folded it along its original crease, and placed it in the manila envelope he had prepared. He would file it with the court. I did not need to keep a copy. Everything was already on record. I drove home on the same route I had been driving for 11 years. I parked in the driveway. I went inside. I put the kettle on and stood at the kitchen window while the water heated, looking at the backyard, the oak tree Owen used to climb, the section of fence I had repaired twice and needed to repair again. Small things, things that stayed.